This article, or this lecture, was actually inspired because I had circumstances where a couple of opposing parties die within a short time of each other, and I'm scratching my head as to what to do next. So I designed this to be sort of a checklist. If you're in a case and the opposing party dies, or you've got a final order, and your client's ex-spouse, parent of the child dies, hopefully you can go to this and all questions will be answered. I'm going to go through issue by issue. Divorce. If you're in the midst of divorce proceedings and the order has not been signed, file with the court. What you've got is a widow or widower. And there's a case right on point, Bain versus Bass, where the judge had issued the oral ruling granting the divorce. The order had not been filed yet. And when it was pointed out to the judge that the other party died, the other party committed suicide, actually, that order, the judge vacated his own order, vacated the award of attorney's fees to the surviving spouse's attorney, and that's what you get for not getting your orders in quick. So I guess my advice on that is get your orders in quick. Alimony. Alimony, looking here at final orders, all but lump sum alimony is terminable on death. And lump sum alimony, I wasn't surprised when I reread the statute, that it's the one form of alimony that doesn't terminate on the supported spouse's remarriage, but it does terminate on the death of the supported spouse, but not the death of the payor spouse. And I'm not really sure why I understand why it's not terminated on the death of the payor spouse, but my understanding of lump sum alimony is designed to compensate in a lump sum the supported spouse. There's no reason it should terminate upon her death. Generally it would be her, but it does. So in drafting your agreements, a lot of times I've used lump sum alimony as sort of a substitute for equitable distribution when we're trying to deal with some tax consequences. And you need to be aware, though, it will terminate upon the supported spouse's death if you've got lump sum alimony payable over time. Child support. The statute, unlike child support the statute on alimony, the statute on child support is silent on the issue of whether it terminates on death, but there's a couple of cases that hold that it terminates on death. And I think you're in pretty safe ground telling your client that child support terminates upon the other spouse's death. Now, big issues, at least a lot of cases I litigate, strikes me that almost every case I'm handling where I represent the non-custodial parent, the other parent's asking for life insurance on my client, the payor, the supporting spouse, the supporting parent, non-custodial parent, and I've never seen the courts award it. And if you read the case law, the courts almost never award it. And if you read the case law real carefully, there seems to be a tendency for the Court of Appeals to overturn the award of life insurance. And I almost never ask for it when I represent the custodial parent or the supported spouse, because I just think that it's very difficult to get. You're going to spend a lot of money fighting for it, and you're probably not going to get it if it's litigated. And I think a much better way to handle life insurance for both the alimony and child support is to have an agreement, and I've never seen the other side reject this, where the supported spouse or the custodial parent has the right to get life insurance on the other parent or spouse. And that makes sense for a lot of reasons. First of all, that person is in a much better position to know how comfortable they are, what level of risk they're willing to accept, vis-a-vis the other, not having that form of support, so they're in a better position to know how much insurance they should get. And also, generally, the person who's going to be wanting the resource, it should be the same person that's paying for the resource, so that they don't overuse the resource. Tendency is when you've got the supported spouse able to impose the cost of insurance on the supporting spouse, they're going to overconsume that resource because it's a free resource to them. So you can cut through it's not as great for your client, but you cut through, but you're generally not going to get a life insurance order, and you're generally in much better shape if you just ask for the right to purchase life insurance on the other spouse or parent's life, and then the courts will generally either order that or it'll be, I've never seen the other party reject that proposal. And I would point out that the same rationale that because custody often flips on one parent's death, the same rationale that would have someone getting life insurance on the non-custodial parent would also suggest that you should get life insurance on the custodial parent, especially if the custodial parent does, work for a living and pays, and has contributes some financial support for the child or children. If that parent dies, you're going to be out that source of support, and the children will need that support. Going on to child custody, there the law is much more unclear than the first three topics I've discussed. It's not clear when the custodial parent dies whether the non-custodial parent can just pick up the child and get custody. If you look at the statute 20-7-100, and it would appear that it should happen automatically, because that statute says that both parents are the natural custodians of their children. And so if one parent's dead and the other parent's the natural custodian of the children, it should seem that they should have custody. But you've also got the Kay versus Rowland case, and there's a couple other cases that cite the same general proposition, that is, when you've got a fit parent, and that's the only parent there is, that ends your inquiry, that person has custody. So if you've got a dead parent and a fit parent, it would strike me that the fit parent has custody automatically. That would be what would strike me, but then you read cases like Moore, and Moore basically says, well, not so fast. If you've got a custody battle between a parent and a third party and the child has not been living with the parent for a while, you don't just start with the presumption that the parent has custody. You've got to go to these Moore factors. And the Moore factors laid out, parent needs to prove that they're fit, provide the child a good home. They're going to look at the amount of contact that the parent has had with the child, the circumstances in which temporary relinquishment occurred, and the degree of attachment between the child and the third party. Now, when you apply the Moore factors and when you apply the 20-7-100 or the Kay versus Rowland factor, there's no discussion that's in any of the cases. There's no bright line test. I mean, it's a issue that you would think would repeatedly come up because there are a lot of custody cases between parents and third parties, but it's never addressed. And at some point, hopefully, the Court of Appeals of the Supreme Court will address it. If you look at the application of the Moore factors, it's all over the place. You can find, with not too much research, a lot of cases where the Court of Appeals reverses award of custody to the third party and finds that it should go on to the parent. But you can also find a lot of cases where the Court of Appeals says, you shouldn't have awarded custody to the parent, you should have awarded to the third party. So what this means is if you're representing a non-custodial parent and you're reaching an agreement on custody with the custodial parent, what you want to try to do is think about ways to minimize the potential that if the custodial parent dies, that your client is going to be involved in a lengthy custody dispute with third parties. Generally, the deceased parent's family will often intervene and try to get custody at that point. My two ways of doing it, one is to try to get my client labeled secondary custodian. I'm not sure if that helps, but it can't hurt. The second is to encourage that client to have substantial visitation and contact with the child. A lot of times you can get a client, a nice visitation order, and if they don't exercise it, I think they're much more likely to end up in a Moore-type third-party custody case than if they did exercise it. The most confusing issue when a party dies is equitable distribution, and that's because it's very clear from the statute that equitable distribution is not ended, an equitable distribution case is not ended by a party's death. And so if you're representing the surviving spouse, Generally, unless the non-surviving spouse had a lot of marital property that wasn't titled in the surviving spouse's name, or jointly titled, generally the surviving spouse is going to be better off if the case just goes away and equitable distribution isn't dealt with. I've never had a circumstance where I represented surviving spouse and we didn't want the equitable distribution case to go away. And that's because a lot of stuff that would be equitably distributable, if the one spouse dies, the other spouse gets it automatically. Real estate that's jointly titled, it becomes solely titled. Insurance proceeds, a lot of times, will come to that spouse. Even things that might not be part of the marital estate would pass to that spouse if the other spouse dies intestate. On the other hand, the deceased spouse, if you're the attorney for the deceased spouse, you need to take action pretty quickly. And the reason you need to take action pretty quickly is because equitable distribution has not ended, but will end if you don't take action pretty quickly. And it may well be that the estate of the deceased spouse is entitled to substantial equitable distribution. Now, if the deceased spouse dies without any children and without a will, you definitely don't want to seek equitable distribution, because what's going to happen is whatever the estate gets goes right back to the surviving spouse. But there will be a lot of circumstances where the estate might be able to distribute the marital property that's awarded as part of an equitable distribution award to the non-surviving spouses, to other persons other than the surviving spouse. So what you don't want to have a situation is where you're the attorney for the deceased spouse, your client dies, you do nothing, and then 3 years later you get a notice that the estate is suing you for malpractice because you didn't preserve the marital estate and get the estate a portion of the marital assets. So what do you do if you're the attorney for the deceased spouse? What you need to do is find a substitute party. And Rule 25, the Rules of Civil Procedure, specifically authorizes and sets out the standards for finding a party to substitute upon the death of one party to a lawsuit. Generally, it'll be the executor of the estate. If there's no executor of the estate, a lot of times you can ask the court to appoint the deceased spouse's either parent or adult child or sibling. But you need to get somebody appointed, because until you get somebody appointed, you have to stand in the deceased spouse's place. You don't have any authority to dismiss the equitable distribution case. Most of the time, you're going to dismiss the equitable distribution case if you're the attorney for the deceased spouse. But if you don't get somebody appointed who then gives you authority to dismiss it, it can be dismissed automatically because you failed to get a party in that person's place. And if it gets dismissed automatically, I would submit that you're submitting yourself to a malpractice action. So the safest thing to do when you represent a deceased spouse, well, when you represent someone who then dies in the middle of the case, is to get a party substituted, let that party decide to dismiss the equitable distribution case or go forward with the equitable distribution case. But if the equitable distribution case gets dismissed because of your own inaction and not getting a party substituted, you're going to be in trouble.